Good morning, everyone. Today is Wednesday, April 15th, 2020. It's approximately 10:03 a.m. Pacific Standard Time. Thank you once again for joining us on this podcast. We are joined by the Family Law Matters legal panel. I do want to remind the participants as they join to make sure that you are muted. And if you have any questions, please make sure that you send them to us. You can do it in one of two ways. You can either raise your hand in the Zoom chat room, or you can just message us in the chat your question. Let's start with the introduction. So Gina, tell us about yourself.
Hi, I'm Gina Famularo, and I am a partner at Family Law Matters. I've been an attorney for 22 years. I've practiced only family law during that period of time.
Thank you, Gina. Christy?
Good morning, everyone. My name is Christy Bergamo. I'm a senior family law attorney here at Family Law Matters. I've been practicing 17 years. In Southern California. I am also an instructor at University of California, Riverside for their paralegal program, and I have been certified to be minors counsel in courts.
Thank you, Christy. Colleen.
Good morning, everyone. My name is Colleen Robinson. I'm a family law attorney here at Family Law Matters. I've been practicing for 10 years, predominantly in family law. I have appeared mostly in San Diego County and Riverside County, as well as all over Southern California.
Thank you, Colleen. And I am Bishoy Shahada. I am managing partner here at Family Law Matters. I've been an attorney for a little over 2.5 years, and family law is all I know as usual. So let's get to it. Gina, today we're talking about child support. So what is child support?
Sure. Child support is money paid by one parent to the other in order to maintain the lifestyle of the child. So if there is a disparity in the households where one household has more income than the other, the idea behind child support is to allow both parties to have this, to provide the same lifestyle for the children.
So is that then the purpose of child support?
Yes, it's to maintain the children in the lifestyle of the higher earning parent.
Okay, and with that said, how is child support calculated then?
Child support is calculated in California based upon a computer formula. So they take several factors into consideration. Those include each parent's tax filing status, whether it's married, head of household, or single. They take into consideration how many dependents each parent has. And the biggie is they take into consideration how much time each parent spends with the child. They also have a few other factors, for instance, health insurance, daycare costs, etc. They throw these into a computer program, and the computer program spits out a number. We call that number guideline child support.
And what do you mean by guideline?
Guideline child support is the number that is required to be ordered by the state of California, and it is based upon the formula that we just discussed. So the formula is automatically calculated. It's presumed to be the amount needed for the child to live in the other parent's household, meaning the lower earner.
Thank you, Gina. And then how long is child support paid for then?
Child support is paid until one of two things happens. Either the child reaches age 19 and is still a high school, full-time high school student, or is age 18 and is graduated from high school.
And typically, based on your experience, who has to pay it? Who has to pay the child support?
Sure, it would be the higher earner. So if one parent is making, let's just call it minimum wage, and the other parent is making, let's call it $10,000 a month, the person who's making the more money would have to pay the person making the lesser money so that the child is provided with necessities and extras, in fact, of life in both households.
So for a household, each household obviously has expenses.
Sure.
Utilities, leases, things of the sort. What if one party can't afford it? Just based on what's coming in and what's going out.
If what you're indicating is, I don't make a lot of money, I am receiving child support and it's still not enough money to be able to pay my bills, that's a common comment, Bishoy, because there's never going to be enough money. Once child support is paid, it's only going to be a portion of what's needed. It's very expensive to live. And so it's most likely not going to cover 100% of the child's expenses.
And with that said, Gina, how do I obtain child support orders generally?
Sure. Let me just go back though, Bishoy, because
Okay.
I think that there's more that needs to be said about child support.
Okay.
If one parent is paying and the other parent is receiving, the parent that's paying is almost always going to say, I can't afford it. And the parent that's receiving is almost always going to say it's not enough. It's just a supplemental amount, and that is why it is based on a computer program. It kind of squeezes both of them. The parent that's paying, it's going to hurt to pay it. The parent that's receiving, it's never going to be enough.
Got it. Okay, so now with that clarification, how do we obtain child support orders?
Sure. Child support can be obtained through the court process. Colleen's going to talk a little bit about what that means. But as far as somebody who is looking to receive child support, you're going to have a few different options. You're going to need to file court papers regardless of what you choose to do. You can do it yourself. You can go down to the self-help center. You can file paperwork through the self-help center. It requires you to stand in line to fill out the paperwork on your own, to file the paperwork. It then requires you to notice the other side and do it properly through the legal process. And it requires you to go to the court yourself without legal representation to argue what is guideline support. And then once you get the order, it requires you on your own to collect it. You would then be your own attorney. The self-help process is a multi-hour commitment, and there's no guarantee you're going to do it correctly because, of course, you're not an attorney. The other option would be to elicit the help of a document preparer, a paralegal or licensed document preparer. They would prepare the paperwork for you. They typically file it with the court. They'll typically even serve it for you, but you still need to go to the court on your own and be your own attorney when it comes to collecting the support and making sure that the court orders the correct amount. Then you can get an attorney, someone like us who's been filing papers and going to court for years. We would help you with the process start to finish. That would be preparing the paperwork, calculating guideline support, going to the court hearing, and even helping you enforce it. And then, Bishoy, finally, there's one last option. That would be going through the Department of Child Support Services. There's some pros and cons to doing that because they will represent you for free, meaning that they will go ahead and file the paperwork for you. They'll file it with the court, prepare it, and of course serve it. They will also go to court with you and help you calculate guideline support. And then at the end, they will even help you enforce it. The con to that is that it takes months. Typically, it's a 6 to 12 month process to go through the Department of Child Support Services. So if you're in a hurry and you need help, your only option would be to hire an attorney.
Thank you, Gina. Colleen, let's talk about the process. What is the process and how does one party get child support?
Well, as Gina had alluded to, the process to get child support through the court system is to file your request for child support. And with that, it's a set of documents and you have to provide your income information. You've got to file that with the court, reserve your court date. And then you need to, as Gina also said, you need to serve the other party with a copy of that motion that you filed with the court properly through the means in which the state of California is deemed appropriate to serve somebody with the motion. And then you've got to prepare for your hearing and appear at your hearing whenever that date is. And then at that hearing, the court is going to be looking at the financial information of both of the parties. Also, what is the timeshare that's involved? This is information that's going to be inputted into the computer program that Gina was referring to. In Riverside County, it's called X-Spouse. In San Diego County, it's called DisoMaster. And that computer program has the algorithm that the legislature has codified, I guess, as to what our support calculation is. That we now use a computer program rather than handwriting it all out and trying to figure it out. As most people know, attorneys are not, we're not mathematicians. And so we use this computer, the judge uses this computer program to figure out what child support is based upon timeshare, based upon the incomes of the parties, and sometimes other information as well, if appropriate.
So I know you mentioned that you have to file paperwork with the court. Can we collect child support without filing documents with the court?
Sure, that's a good question. You can, as we've mentioned before, you can reach whatever agreements you want between you and the other party. The problem is that if you're getting child support without a court order or a stipulation or something in writing that's been filed with the court, that other party has no obligation to keep paying it to you. More importantly, so they can just stop paying it. And then now you have no other recourse, because it's not an enforceable court order. If the two of you just came up with the number and the other party said, sure, I'll pay you $300 a month, and that was just an agreement between the two of you, and they stop paying, now you're SOL essentially. You've got to file something with the court at that point. So yes, you can, and some people do, but then once they stop paying that amount, now you have to, in my opinion, you need to go through the court process, where if you maybe would have taken that agreement and reduced it to a writing to a court order, now you've got an enforceable order. Now you can go collect it if the other party stops paying. And it's much easier to do that rather than have to start the process from the very beginning.
And I know Gina mentioned that there's 4 ways, that the 4 options to getting child support, which is the do-it-yourself, paralegal, an attorney, or DCSS. Is opening a case with DCSS considered filing with the court, or is that separate?
Well, no, it just depends. With DCSS, they would open up a self case for you. And as Gina said, it is a process. They would file their own set of paperwork with the court, because everything's got to start with paperwork with the court if you're going through DCSS or if you're filing a motion. And also where your starting point would be as well. Either you have to open a paternity action, or you have a dissolution as well. So you need to have those vehicles first before you even file your motion. And through DCSS, they would file that as well. And as Gina had said, DCSS, they're not your attorney. I just want to make sure this is clear. They're not your attorney. They're not technically representing you. They're representing the interests of the child to make sure that the child is supported. So while they're doing the service for you, it's not for you per se, it's for your child. So they're not going to be looking out for your interests necessarily either. So anyway, the DCSS would either file a petition or a paternity action to get child support and start the process that way. And I think that answers your question in a very long-winded manner.
Yeah, it does. So I want to get back to your earlier point about if you reach an agreement outside of court, that's great, but it's unenforceable.
Right.
So if I understand you correctly, yes, people can agree to a different amount. And if people do agree to a different amount, can that number then be made into a court order?
Yes, it absolutely can. It's not as straightforward though with child support, because you still have to show the court, you have to provide enough information to the court to support why if your number, let's say, is lower than guideline support, you have to provide the information to the court to make that okay. The courts, there's statutory language that has to go into all child support orders. So yes, you can come up with whatever number you want. It gets a little nuanced with child support orders because there's state required mandatory language that needs to appear in those court orders. So you reach an agreement, great. You're almost there. You're not quite there. You need to reduce it to a writing, and then you need to make sure that that writing comports with what's required for a child support order. So that's where consulting with an attorney or having an attorney comes into play for you, because the last thing you'd want to do is have an agreement and then it gets rejected by the court, or you're unable to collect on it, or delay. You definitely, if you're in need of child support, you certainly do not want to delay.
Thank you, Colleen. Now, I know you and Gina have mentioned that the child support mainly is calculated based on 2 factors, the income of the parties and the amount of time spent with both parents. So my question to you then is, if the parties have a 50-50 custody order, does either one still have to pay the other support, or would either one?
Well, it depends. We still have to run the numbers through the support calculator. So just because you're at a 50-50, a lot of people assume that means I don't have to pay child support. That's not necessarily true. And in fact, in a lot of cases, that's just not true. That even in that scenario, a parent may still have to pay child support. The other factor, as you just said, is the income of the parties. So we have to look at the income of the parties, and it's not just with timeshare. So we still need to run the calculation.
And what if one party loses their job? So let's say I'm the payor and I lose my job. What happens with the child support? What can I do?
Well, just as we discussed with spousal support, child support is always modifiable. So if you run into a situation, I know we've talked about this with our COVID podcast, that a lot of people right now are going through changes in their income, either losing their jobs or pay is getting reduced, is that you need to file a motion to modify support, and also reach out to the other party and explain your situation and see if there's any agreements that the two of you can make that then you will reduce to a writing. But if not, you need to file a motion to modify support based upon your change of circumstance, your change of financial circumstances.
And what if the receiving party, or I guess either party, the payor or the receiving party, what if they're working under the table?
Ooh, that's a tricky one. The problem is that when someone's working under the table, you have to prove it. So you have to show the court they are working, they are earning an income, whether it's a cash business or perhaps they've got another job somewhere. You've got to be able to prove it. So in a lot of situations, it's hiring a private detective, a private investigator to follow that person around to show that they're working, where they're working, like transactions or anything along those lines, or to be able to see monetary transactions. There's also discovery that can be done. So we can, as an attorney, you have a motion that's filing or pending for child support. You can ask for the other party to produce financial documents. You can ask them to produce bank statements. You can ask them to produce credit card statements. Because even if they're working maybe under the table, their expenses are so high and their expenses are getting paid, you can then, I would, as an attorney, argue to the court that their income is clearly, there's a huge disparity between what they're reporting and then what they're actually earning, because now their living expenses, they're paying off their credit card every single month, or maybe they just bought this fancy new car and they're claiming they're making $12 an hour, not working at all, or working part-time, or whatever the situation may be. You've got to be able to paint a picture for the judge that what their income, there is more to the story than what they're purporting their income to be. And that's either through discovery or using a private investigator or something along those lines. But that's when you should talk to an attorney and we can come up with a strategy on how best to present that, or how to get that information to present to a judge at the time of their hearing.
And what about college expenses? Does the payor have to pay for college expenses?
In California, unfortunately, despite how expensive it is to put a child through college, it's not an obligation for a parent to pay for college for their children. So a court can't order you to pay for college for your child. However, the two of you can make agreements however you wish in regards to college education and those expenses.
Thank you, Colleen. And then one of the most common questions I get as an attorney is, how can I make sure that that money is actually being spent on the children and the receiving party is not just using it for, her personal expenses?
Yeah, that is a very common question. And I've also gotten questions, well, can't we just put it in a joint account where I can monitor where the money's being used and make sure that it's being used for the children? And the answer is they don't require that here in California. That it's a presumption that the payee or the receiving parent of the support is going to use that to support the children. There's no other requirement beyond that. The other parent doesn't need to produce receipts every month to show where that money went, or like some sort of tracing or anything along those lines. Before we started recording this podcast, Christy was actually sharing a story where a parent had gone and misused those funds, and perhaps that's a situation, a case-by-case situation that you could go in and modify. modified child support if you have the proof and the evidence to suggest that the opposite is occurring and it's to the detriment of the children. But I would say that's pretty specific. Otherwise, there's no other requirements that the parent receiving support has to prove that those monies are only being used for the child.
Thank you, Colleen. There's two other questions that I typically get. Let's say that the parties were previously married and have since been divorced and remarried.
Okay.
How does the new family's income affect child support, and does it affect child support?
So like new spouse's income, for
Yes.
example. It doesn't actually. There's no requirement that third parties beyond parents pay for child support. The only, so for example, if you're remarried and your spouse is making whatever amount of money, that amount does not get tagged on or added into your side of the ledger on the ex-spouse or disto master. The only way, or the only why it is used, and the court and the judge will ask, like, how much does your spouse make? Because they need to include that for tax purposes. Which tax bracket do you fall into? And that's the only place where it comes into play, is just what is your tax bracket. So you do still have to disclose it, but it's not added in. It's not added to your monthly income to then calculate what child support is.
What about the opposite side, where there's a new family, right? I've moved on, I've remarried, I have a new family, and I have additional children. How does that affect me having to pay the initial child support order, or does it affect the amount of child support that there is because now I have more, or I don't know if we want to call it more family, but more family members?
More kids. So it depends. That's a common answer. It depends. You may be able to qualify for a hardship deduction. That's something that needs to be pledged specifically and argued at court, and whether or not the judge will, it's a completely discretionary for a judge to give somebody a hardship deduction, like with a new baby, for example, because babies are expensive, more children are expensive. So it really depends. I know that it's kind of, my experience county to county varies as to when a court will give a hardship deduction like that. And it does go into, you do have more dependents, so that's going to be factored into with child support. So I guess the short answer is it just depends with having more children, whether or not that's going to change your child support obligation.
Thank you, Colleen. Christy, let's talk about some add-ons. What add-ons can be included in a child support order?
Well, the add-ons are childcare costs, so that will be a factor the court will consider in terms of paying child support, whether or not you get a credit for that, or it's something that the payor has to pay you for, or it might just go into the ex-spouse and will be reflected there, so it may reduce support. But there's one caveat to childcare, and it is that it has to be for work-related childcare. So if you have a babysitter coming over to your house on the weekends, that's not something that's going to be factored into this equation. It's got to be for work-related childcare, and sometimes the person who's receiving the support has childcare on top of that. You know, that's a factor. And then if the payor has childcare to maintain their employment, that is a factor for sure. Another add-on that is mandatory is expenses as it relates to unreimbursed medical expenses, dental expenses, those expenses that after you pay health insurance, obviously you have co-pays, you have deductibles, things of that nature. Those will be you will be ordered to share equally in those expenses normally.
And how do I collect those add-ons?
That's a more difficult process, because obviously when you receive the order, it is just going to simply state that you both have to share in those expenses equally. Well, at the time the order's made, no one knows what those expenses are going to be. So there's a process that you have to follow in order to recover those expenses. And you have to give notice to the other side, present the bill, present your proof of payment, And then there's a certain waiting period. I believe they have 30 days to pay that expense. Well, the common question is, what if they don't pay that? So say, for instance, I'll give a scenario that the child had to have a cast put on their arm. So the expense for all of that was $1,000. I'll just use that. After health insurance paid for whatever they cover. So both of you would be responsible for $500 of that. And you fronted the cost of the $1,000. So you have to send proof to the other side that you did pay that. And then you have to wait. I believe they have 30 days to pay it. And if they don't, the question is, what do I do now? I'm out $500. The code requires that you actually file a subsequent motion, a request for order. And it's a request for the court to determine arrears, something that is owed to you, owed back to you. So you would file that with your proof that they paid it, and then the court would have to find what the amount the other party didn't pay. It seems a little unfair because it requires you to file another request for order, but it's simply, that's how the process goes. And where we come in is obviously we can assist you in doing that. I don't think a lot of people know that, that they have to file a subsequent request to have that determined and have the court order the other side to pay that.
And can extracurricular activities be included or added on?
Unfortunately, no, that is not a mandatory add-on as per California statute. That's why when you are signing your children up for those extracurricular activities, you want to make very sure that the other side agrees and obviously is going to help you pay for it, because that's not something the court is going to get involved with. Obviously, a child-focused parent would agree to those things and agree to participate financially, but they're not obligated to do so. And I get that as a common question that, well, they agreed to it and they're involved in it, but they're not paying for it. And the answer is that's unfortunately on you.
And what about private school costs?
Private school is the same way. So again, the rule of thumb would be to get an agreement with this person, the other parent, and just hopefully they'll pay for it. But if they want to stop paying or don't want to pay, then those types of obligations are going to be completely on you if that's what you want your child to have.
And therapy, counseling for the children?
Counseling's a little different. Counseling, I believe, falls under the category of unreimbursed medical expenses, health-related expenses. So I believe that would be covered under under an obligation. But I always tell my clients, you need to check the specific language of what your order says if you already have an order. So this is more enforcement. But if you don't have an order yet, again, it is a good idea to have an attorney assist you in this so that you can make sure when the court makes the orders or you're coming to an agreement that those types of things are included in your order so that you can enforce that.
Okay, and then what about health insurance? If one party, if one party has health insurance, does the other party have to maintain a health insurance for the children?
Health insurance is the person who, well, if the question is someone already has health insurance for the child, so usually that's factored into the child support order. We keep talking about this calculator. So the person who's paying it, whatever that amount is, I find the range to be between anywhere from $300 to $500. So that would be given as a credit to the person who's paying it. So it would thereby reduce their support by that amount. And if the question is, if they have insurance, do I have to insure as well? No. If you want to insure to have like a double coverage, which I think is the best plan, then you too would receive a credit for whatever health insurance you're paying. And a follow-up question or issue I get to that is, what if I lose my insurance? Then that requires a modification of the support to the supported party, because then they shouldn't be still receiving that credit. And maybe you're going to have to insure the child now because the other party left, or strike that, the other party lost their insurance. So those are all issues that you need to consult an attorney about, because those are adjustments that need to be made to the child support calculation. And they're significant sometimes. So it's worth a call to say, hey, you know, these are the facts regarding the insurance, and how does that change the support, if at all?
Are both parties required to maintain health insurance? Is that the default?
It is the default. But I mean, that's a little tricky in the sense that the requirement is that, and it depends on what the judge orders. So my experience has been that if one party's covering the child at the outset of the case, then they are going to be ordered to continue that, okay? So if both parties are covering the child at the outset of the case, then that's going to be the order. But the caveat is, the order only remains if it is at a reasonable cost, okay? So I've had cases, in fact, I've had cases where insurance at that employer goes up considerably. Then it might not be reasonable for that person to have to continue to cover the child. It happens a lot in, so say someone loses their job and only COBRA is available. And COBRA, as we all know, is extremely expensive, in the thousands of dollars sometimes. So that might not, like I said, the order is that it's reasonable. So that might be a circumstance that may require a modification as you know, just for those facts alone.
Thank you, Christy. I want to shift now specifically to the issue of collections. So what if the receiving party quits his or her job? What can I do for child support?
If the receiving party quits their job, you mean the paying party or the receiving party?
Let's start with the paying party first.
Yeah, let's start there. So the paying party quits their job, and the person who's receiving it is no longer receiving it. The people need to understand that if that's the case and the paying party doesn't go in to modify that in some way, and it just based on the facts of, you know, did they quit their job on purpose? Did they quit their job because, you know, for some other reason that's not so much their fault? The support order doesn't change until somebody modifies it. I think that's the simplest answer. So if the person quits their job and you had an order for $500 a month, then that order continues until the person who quits their job files some sort of request to modify. So what happens is that arrears start to accrue, and that means it just kind of builds up in your bank, and it will also have interest attached to it. So it's right now it's 10% per annum, which means per year. So they're going to be obligated not only to pay that back, but also the interest that's accruing while they're not paying. So if you're the receiving parent and you lose your job, okay, so you now require more support, that requires a modification by you. So you lose your job, and you know the other parent's still working, you're going to need to request a modification upward of your support based on your financial circumstances. And I don't know if that answers the entire question. Okay.
Yes. Now, let's talk about what if the receiving party refuses to get a job? What can the payor do at that point?
You know, that's a common issue. You have the person who's going to be obligated to pay the support, and they have evidence, or they know that the other parent simply doesn't want to work, doesn't care to work, all of those things. And it's a fairness issue, I think, with the paying party. Is like, I'm out, I'm working, I'm paying, and why does the other person get to just sit home and collect? And the court does consider those factors, and the court has a number of ways that they can handle that. They can impute income, which means they can decide that your evidence was substantial enough to show that they have an ability to earn. They can order the supported party to produce evidence to them that they are trying to get a job. That's a common order that's made, because the code says expressly, at the beginning of the code section on child support, it says expressly that both parents have an obligation to support their child. So if there's one parent that's lacking the drive, if you will, the drive to support their child, you can present that evidence to the court, and it is a factor the court can consider. But it's tricky. You can't just walk into court by yourself and say, Your Honor, I think they have an ability to work. It's a lot more complicated than that. And I think if you have those types of issues, imputation of income, discovery about what the other party's doing to be self-supporting and supporting the child, those are things you want to consult us about, because it's a strategy. And I've seen more often than not, when people go to, I say this over and over again, when I see people who represent themselves in court, especially as it relates to financial issues and as it relates to custody issues, nothing saddens me more when they have clearly not done the process right. And the relief that they're seeking is to me, as I'm listening, to me is straightforward and something I can help them with. And it makes me cringe in my seat, because I just want to jump out and start representing them, because I know that they're not going to get what they need from the court, because they simply just don't know how to do it. And it's to no fault of their own, but we know how to do this. I know what arguments to make to the court. I know how to get you the relief that you need. And it's sad to see that it happens over and over and over again.
Agreed. So I think everybody kind of hinted towards this, and it's the fact that child support can be changed in the future. Is that correct?
Absolutely.
Go ahead.
Yes, absolutely. It can be changed. And the process is the same, the way Colleen described it. You have to file a request. What we say in these podcasts as well is that the relief you're seeking, you have to put something into the court system to ask for that relief. You can't wait. So if the circumstances change, say you lose your job, you can't just stop paying. You have to file a request for order to seek that relief from the court. And people more often than not, I've had cases where the parties had an understanding, oh, you lost your job, you don't have to pay me right now, and then we'll figure it out later. And I see parties rely on that. And then years go by. And then all of a sudden they get a motion to determine the arrears, and they owe like 10, 20, sometimes hundreds of thousands of dollars in child support arrears because they never filed their request to modify, or they did not get a written stipulation. So again, it is in your best interest, whether you're the payor or the payee, when your circumstances change, you need to consult an attorney so that you can figure out how you need to do this to preserve and protect yourself.
And then I have one final question for you on that note, Christy. What happens when the child or the children turn 18? Does child support stop automatically?
It should, but I would consult an attorney again to see how your order is written. I think it's always a good idea to get a stipulation to terminate the child support and file it, just to be safe, because again, you just don't, statutorily it's supposed to end, but I've seen orders where the child support is just one amount. So say there's 2 children, one reaches the age of 18 and ages out, but the support just says $1,000. It's not differentiated what child received what, if you will. And in that situation, you have to go in and modify, because the child support's based on 2 children versus 1. It's just always a good idea to call us. It may be a simple answer, it may be a simple solution, but why not ask and make sure that you have the right information.
Thank you, Christy. Colleen, any final comments?
I think we were pretty thorough today. I don't have anything else to add to that.
Thank you, Colleen. Gina?
Only that people should not take for granted their rights and the process. Just because they're entitled to child support, just because it is collected through the courts, or it can be, just because there is a guideline that is used to calculate support, doesn't mean if you don't go in with the proper legal help or go in without the proper legal help that you're going to get a just decision. So make sure that you retain competent counsel anytime you're seeking or enforcing a child support order.
Thank you, Gina. And I want to take this opportunity to thank you guys for joining us again today and taking the time out of your day. I do want to thank our participants for joining and remind them that this recording will be posted on all of our social media websites, Facebook, YouTube channel, and our website. And if you do have any questions concerning child support, feel free to reach out to us. As always, you can reach out to us in one of 3 ways. You can call us at 951-587-0505. You can send us an email at info@temeculadivorce.com, or you can join or visit our website and request a consultation. And our website is www.temeculadivorce.com. Again, thank you all for joining me, and God bless.
Bye.
Bless.